Good evening, everyone. It's showtime. It's 9:40. I'm Teddy, and it's Analyze This Mess tonight. And to the Honey Bears and the Grizzlies, yes, we're going to get into what is the latest update in the docket. And tonight, I also have my co host. I don't know how this is all going to work, but we are going to do our very best. Are you out there, Blade?
Yeah, Teddy, I'm right here. Blade, reporting in. Honey bears, grizzlies, good evening. Let's cut through the noise. What's on the docket tonight?
Well, tonight we're looking at a situation where the court asks one very specific question. Why did you not follow a direct court order? And why shouldn't you be held in contempt and be sanctioned? And instead of answering that, the defendant responded by re arguing whether the order should exist in the first place. That's not the same thing. And the
Got it.
and the court,
Teddy, and the
yes,
court.
go ahead, Blaine.
Teddy, and the court.
Yes.
Blade. All right, let's keep it moving. Blade. Yes. Picking right up. The court already ruled on anonymity, already rejected the First Amendment argument, and the court made clear that order stands, must be followed, unless stayed. So what we're seeing? Not compliance, a procedural pivot, delay tactic, handing it off to Judge Levy so she doesn't have to cough up the name tomorrow. Teddy, your turn. Keep rolling if you want, or pause here.
Well, I think it's an attempt to delay enforcement, move the issue, as you said, to the district judge, and avoid immediate consequences of non compliance. And the key question now becomes, will the court accept this as a valid response, or will it recognize that the original question was never actually answered? Let me just pause. I'll stop Blade just for a moment. The final truth, though, I think, she's not confused. She's not misunderstanding. She's avoiding the consequence phase and trying to drag this out. We're going to take a look at what the order was, just briefly, and then we're going to take a look at the response. All right, so we are going to get into this. Give me a second. I stop Blade for just a moment, and I'm just wondering if I want to bring him back on. Hey, Blade, are you still there? It's Teddy and the mob on Wine with Teddy, and it's Analyze This Mess. We're going over ECF 144, 148. Do you still have that, or am I going to have to upload it for you? All right, so tonight there's been just a little bit of a technical delay. Let's see if I can get Blade back. If I can't, I can just keep going as I looked at this. Try one more time. Hang on, I'm going to stop this. Hey, Blade, are you there? It's Teddy. All right, let me just stop it and just tell you really what's going on, if I can. So, tomorrow, the 24th, was the deadline, and the judge was expecting a response to explain why the defendant shouldn't be held in contempt and sanctioned. Also, on ECF 144 in her order, let me just pull it up.
Got it. Pulling up the latest on that case.
Wow, you have it? Go ahead.
Okay, pulling up the latest on that filing. Hang on. Yeah, I pulled up what I could. Honestly, nothing pops for an ECF 144 tied to a March 24th deadline tomorrow. Closest stuff is older contempt motions in that boat repossession case.
All right, so I haven't uploaded that to him, so I'm just going to keep going. I have 144 up, and in that order, we're going to go right to this portion, and then I can get it uploaded for him. Going to go right to the end. The conclusion, the court thus grants Evans' motion for an order to show cause, ECF number 134, by March 24th, 2026. Robertson must show cause why she should not be held in contempt and sanctioned for her defiance of Judge Levy's orders to disclose her legal name and postal address. That was ordered on March 3rd. Understanding that this notice also followed to parties about objections. So, what the defendant did instead, it appears that rather complying, she argued, as I mentioned, what I thought might be part of that argument, First Amendment, and so forth. I'm going to show you that. We're going to go through a portion of it. Hang on, I was just trying to see if I could upload it. That way is here. Hang on. Hang on. Throw this up. Again, I don't know if the responses are going to be delayed or not. So, did you get ECF 144 and 148, Blade? All right, so he has them both. I'm going to have to stop because the voice stopped. I'm going to try this again. Hang on. One more time. If it doesn't work, then I'm just going to get into it. Hey, Blade, are you there? It's Teddy. I'm trying to upload ECF 144 and 148. Did you get it? We're going to see. Do you have it? Blade, are you there? Again, I'm just going to give him one more chance. Then I'm going to stop. All right. So let's just continue. Pull this up. All right. As I was saying, at the end of that order was this notice to the parties about objections. So there was a 14-day after being served, which would have fallen on the 20th. But then 3 days were added to it, and that came in today. So when an objection is filed, it says to the magistrate judge ruling on a non-dispositive motion, the ruling remains in force and effect and until it is stayed. So the defendant also asked for a stay. Okay, let's go to it and go through it. Not all of it, but in part. Hang on. All right. This is the defendant's response. Objections to magistrate judge's order and motion to stay enforcement. Okay. I'm going to read the beginning of it, and then I'm just going to point out, I think, some of the highlights. So, this filing is timely pursuant to Federal Rule of Civil Procedure 60, which provides an additional 3 days, making the deadline March 20th, 2026. Defendant appearing specially and without waiving jurisdiction objections respectfully submits the following objections pursuant to Federal Rule of Civil Procedure 72A and requests that the court stay enforcement of the order compelling disclosure of the defendant's identity pending review of these objections. So, to begin with, objections. Not a response providing name or address of the defendant. Okay. Statement of respect and clarification of defendant's position. Defendant respectfully submits that she has not defied or disregarded this court's authority at any stage of these proceedings. To the contrary, defendant has actively participated in this case by filing motions, objections, and responses in accordance with the federal rules of civil procedure. Defendant's actions reflect a good faith effort to preserve constitutional and procedural rights, not as an attempt to evade the court. Evasion would involve a failure to appear or respond. Here, defendant has consistently appeared, responded, and sought judicial review of orders she believes implicate significant constitutional concerns. Just pause for a moment. So the court already established defendant was ordered twice to disclose her identity. She did not comply. She did not properly appeal. Instead, she chose non-compliance. The court explicitly said orders must be obeyed even if you think they're wrong. First Amendment does not excuse ignoring the order. The argument was waived, belated. The order is still binding. Law of the case. Show cause why she should not be held in contempt and sanction. Not explain your feelings. Re-argue anonymity. Submit another essay. The question was one thing. Why did you not comply? And why shouldn't we punish you? I continue with this. From the outset, defendant has maintained that this case involves compelled disclosure of identity and protection of anonymous speech. Defendant therefore entered a special appearance and expressly preserved her rights, including objections to jurisdiction, service, and compelled identification, ECF number 28. That was last May. Defendant continued filings, including motions to dismiss, objections, and requests for a stay, reflect compliance with the judicial process and reliance on established legal mechanisms for review. Seeking relief through motion practice is not defiance. It is the proper method by which litigants present legal arguments to the court. So in 144, Judge Stafford, let me just look through here on a different screen. That way I can respond to both. In Judge Stafford's order 144, it reads, to justify her defiance, Robertson may repeat her argument from her October 2025 motion to dismiss that the orders to disclose her identity violate the First Amendment protections against unmasking anonymous online critics. As recognized in the court's recent report and recommendations, she goes on to say Robertson is correct that authors' decision to remain anonymous is an aspect of the freedom of speech protected by the First Amendment. And then she cites a case. Thus, case law supports Robertson's position that the First Amendment may be protected against disclosure of her identity. But, as stated above, finding a disobedient party in contempt is appropriate, even if the order is later found incorrect. And Judge Levy's determination that Robertson must disclose her identity is the law of the case and may not be revisited absence extraordinary circumstances. I come back here. The defendant is saying seeking relief through motion practice is not defiance. It is the proper method by which litigants present legal arguments to the court. To the extent the court referenced a sword and shield concern, defendant respectfully submits that such doctrine is inapplicable here. Defendant is not invoking anonymity as both a sword and a shield to obtain affirmative relief while avoiding accountability. Rather, defendant is asserting anonymity defensively to protect constitutional rights while responding to claims brought against her. Courts distinguish between offensive use of anonymity and defensive invocation of constitutional protections. The sword and the shield doctrine generally apply when a party seeks affirmative relief while selecting withholding information to gain a litigation advantage. Let me just pause for a moment. Let me see if I can find. I don't see your comments, is why let's see. I'm trying to find, okay, now I can see your comments. It's 10 o'clock. I actually was not going to come on until tomorrow to go through this, but I'm here now. Okay. Long and short of it is she's non compliant. And as I mentioned, she is re arguing, you know, what the judge said we weren't going to revisit. If I'm reading both of these correctly. But I go on. Defendant, however, has not asserted counterclaims, sought damages, or invoked the court's jurisdiction as a sword. She appears solely in a defensive posture and asserts anonymity as a constitutional shield to prevent compelled identification before the court determines whether plaintiff has established a viable claim. Defendant has not initiated claims, sought affirmative relief, or used anonymity to gain an unfair advantage. Instead, defendant has used anonymity solely as a shield to protect against compelled disclosure in a case she believes implicates First Amendment protections. Let me go back to ECF 144. The magistrate judge said, finding a disobedient party in contempt is appropriate, even if the order is later found incorrect. And Judge Levy's determination that Robertson must disclose her identity is the law of the case and may not be revisited absent extraordinary circumstances. A prior ruling may only be reconsidered where one, substantially different evidence is raised or subsequent trial. Two, where a subsequent contrary view of the law is decided by the controlling authority. Or three, where a decision is clearly erroneous and would work a manifest injustice. Even if Robertson argues that the orders were clearly erroneous, she waived her First Amendment argument by failing to assert it in any of her previously filed briefs about the anonymity issue. Although she made the argument in a motion to dismiss, that motion did not concern the orders to disclose her identity. Neither the court nor Judge Levy was obligated to scour the record on Robertson's behalf to develop her argument, nor review or declining to review hundreds of pages of documents that were in the record but were not attached to the relevant motion. As the court has warned the parties, judges are not like pigs hunting for truffles. Robertson did not raise the First Amendment argument in opposing Evans' motion to strike her filings made under an alias or in seeking a protective order preventing Evans from obtaining discovery about her identity. I go back and pick up. In ECF 148, the defendant says, accordingly, defendant respectfully submits that her conduct reflects good faith participation and constitutional advocacy, not evasion or non compliance. Defendant further submits that her consistent assertion of the First Amendment protections arises from her understanding that the claims at issue concern online speech, petitioning activity, and public commentary. Let me just skip through some of this. In her introduction, it reads, "The court is being asked to compel irreversible disclosure of defendant's identity in a case where the magistrate judge has already recommended dismissal of the sole federal claim with prejudice and substantially narrowed the action to a single disputed state law claim. Compelling disclosure under these circumstances risk imposing permanent constitutional harm in a case that may not proceed at all." So, again, what she's arguing once more is this First Amendment, and that a claim, this last claim right now, because the judge has not ruled, the district judge has not ruled on the magistrate judge's rules and recommendations, or report and recommendations, her ECF number 138. But what she's relying on, it seems, that she's reminding the judge that a claim hasn't been, this is her writing, hasn't been established. I'll go on. In her first appearance, defendant expressly reserved all rights and did not admit identity or waive any defenses. That was ECF 28. There have been many filings and many rulings since then. I'm not going to go through, I'm just going to skip through some of this narrative. Let's go to this part. Let's see. Blade, are you there?
Yeah, I'm here. What's up?
All right, so I tried to upload ECF 148 and 144. I will try again. Hang on, pause. Just wait for me. And again, you're joining the mob, the Honey Bears, the Grizzlies, and we're talking about this show cause order. And I've been reading from the defendant's ECF 148. Let me see if I can attach it for you to review. Hang on for a second, everyone.
Got it. No rush. Take your time uploading ECF 148 and 144. I'll wait right here while you sort it out. Once they're up, just say the word, and we can dive into that show cause order together.
All right, so I've uploaded them. Do you see them?
Yeah, I see them. ECF 144 and 148 both came through. The magistrate's order from March 3rd is clear. She's granting your motion, telling Robertson to show cause by tomorrow, March 24th, why she shouldn't get hit with contempt and sanctions for ignoring Judge Levy's disclosure orders twice. And then Robertson's objections just dropped on the 20th, arguing she hasn't defied anything. She's just protecting First Amendment rights. Says the case posture changed with the R&R dismissing most claims. Wants a stay. You want me to break down what happens next, or should we go line by line on her objections?
Well, I'm looking at her objections. I'm on page ECF number 148, page ID 3358, and I'm at section 3. The posture of the case has materially changed and warrants stay. So that's the part where I'm reviewing. Are you there?
Yeah, right here with you. Page ID 3358, Section 3. She's arguing the whole landscape flipped since Judge Levy's disclosure orders. Back then, there was a federal copyright claim keeping things in federal court, but now the magistrate's R&R recommends tossing it with prejudice, leaving just one shaky state claim. So she says, why force her to unmask now when the case might get bounced back to state court anyway? And if jurisdiction vanishes, disclosure's pointless and irreversible. Makes sense as a stall tactic. Buy time, hope the district judge adopts the R&R, and maybe dodge the whole thing. But here's the catch. Magistrate's order from March 3rd already said show cause by March 24th, which is tomorrow. Her objections filed today don't automatically pause that deadline unless she gets a stay granted. And she hasn't shown the court yet why her First Amendment angle wasn't waived earlier, like the magistrate hammered on. You thinking of filing a response tonight, or just want to poke holes in this section first?
Well, I'm not going to disclose what my plans are immediately. Right now, I'd just like to go through her response, the objections, and see if any of it gives her an out to stay the order to disclose her identity. Now, she's appealing to the district judge in this case, objecting to Magistrate Judge Stafford's order by defying Judge Levy's order. How do you think that might land? And again, this is fair use commentary for education, criticism, reporting, analysis. It's not 100%, and it's my opinion with use of AI. Go ahead, Blade.
All right, let's dig into this. Her objections might not stick. Yeah, fair enough. Keeping your cards close. Let's walk through her objections real quick, especially that materially changed posture bit on page ID 3358, and see if it buys her any breathing room on the disclosure order. First off, she's objecting under Rule 72A to Magistrate Stafford's March 3rd order, the one telling her to show cause tomorrow. That means she's asking District Judge Levy to say the magistrate got it wrong or acted contrary to law. Problem is, Levy's the one who issued the original disclosure orders back in December 25 and January 26. So Robertson's basically telling the boss, hey, your own orders? They're bad now because the case shrunk. That lands awkward, like biting the hand that fed her the deadline. On the changed posture argument, she's right that the R&R, probably ECF 138 or whatever, recommends axing the copyright claim, which was the federal hook. If Levy adopts that, yeah, supplemental jurisdiction over the state defamation stuff could vanish under 1367C. Courts hate keeping cases alive just to unmask someone if the whole thing's about to die. But here's the rub. Stafford's order isn't forcing disclosure for the sake of jurisdiction anymore. It's punishing defiance of Levy's prior rulings. The magistrate framed it as contempt for bad faith noncompliance, not we need her name to serve papers. So even if the case collapses later, ignoring two direct orders from the district judge still looks like thumbing your nose at the court. Her waiver point? She claims she preserved First Amendment stuff early, ECF 28, 49, 77, 82. But Stafford already shredded that, said Robertson never properly teed it up in the right motions, used fake citations, and forfeited it by not hitting it in objections. Courts don't love, I mentioned it somewhere defenses, especially when the record's messy. Levy might buy that she waived, or at least say, too late now. Stay chances? Slim. She needs to show irreparable harm. Unmasking's permanent, sure. Likelihood of success, weak if waiver sticks. and public interest. But contempt sanctions are the court's hammer. Judges hate litigants who private determine orders are wrong instead of appealing clean. Sixth Circuit's clear. Obey first, fight later. Unless Levy sees manifest injustice, she'll probably deny the stay and let tomorrow's show cause hearing roll. Bottom line, her objections scream delay, not slam dunk reversal. If I were Levy, I'd see this as more gamesmanship, especially after the fake citation slapdown. Might even fast-track sanctions. But hey, that's my read. Courts surprise sometimes. Want to hit another section, like her sword and shield rebuttal, or just vibe on how you'd counter?
Well, the sword and the shield, let's talk about that one.
Sure, let's dig into the sword and shield thing. Yeah, the sword and shield bit. Robertson's trying to flip the script on what the magistrate said. In ECF 144, Stafford basically called her out. You can't hide behind anonymity, shield, while using it to dodge accountability or mess with the case, sword. Like, if you're anonymous to block service or discovery, but then file motions that force the court to deal with you, that's weaponizing privacy. Robertson counters on page 2 of her objections, page ID 3355-ish. Nah, I'm purely defensive. No counterclaims, no damages, no affirmative relief. I'm just shielding my First Amendment rights while responding to your suit. That's not a sword, that's constitutional armor. She's got a point if you squint. Courts do carve out exceptions for pure defense. Like, in defamation cases, anonymous posters sometimes get to stay hidden until the plaintiff proves a real claim. Think Dendrite or Cahill tests. If she's not asking for anything back, just fighting off the attack, anonymity might stick as a shield without turning into a weapon. But here's where it wobbles. She did file stuff, like that motion to dismiss, ECF 77, objections 82, even the reconsideration that got struck. Each one forces the court to engage, which kinda looks like swinging a sword to keep her identity buried. And Levy already ruled anonymity's off the table, law of the case. So Stafford's line holds. You're not just defending, you're actively obstructing by refusing disclosure after 2 clear orders. If Levy buys her defensive-only spin, maybe she gets a stay or softer sanctions. But honestly, it smells like semantics. She's still defying direct commands. First Amendment or not, courts don't like that. Feels more like a shield she's using to parry the contempt hammer. Want to see how courts usually split this? Real cases where anonymity survived versus got yanked?
No, what I'm doing is moving through. Let's go to section number 5. The defendant did not waive First Amendment anonymity rights. She writes, the finding that defendant's First Amendment argument was belated is contrary to the record and governing law. From her first appearance, defendant expressly preserved anonymity and all constitutional objections. Defendant reiterated that no filing should be construed as waiving anonymity or constitutional protections. That was ECF number 49, page ID 2. These assertions place the court and plaintiff on continuous notice that compelled disclosure was contested. But we've moved on from ECF 28, from ECF number 49. So is she noting to the court that while it wasn't argued First Amendment right, that she's been saying it all along? Or is there something else here?
Got it. Diving into section 5 now. Yeah, section 5. Page ID around 3360 or so, where she hammers no waiver and points to ECF 49, page 2. No filing should be construed as waiving anonymity or constitutional protections. She's basically saying, look, I flagged this from day one. First appearance, every motion. I kept saying, don't take this as me giving up my rights. That put everyone on notice. So how can Stafford call it belated? It's clever. She's arguing preservation by boilerplate disclaimer, not by deep legal argument in every brief. Like, she didn't need to spell out First Amendment unmasking test from Dendrite each time. Just repeatedly saying I reserve anonymity was enough to keep it alive. But here's why it probably doesn't fly. Courts aren't mind readers. Stafford already said in ECF 1440 she didn't raise it properly in the key spots, like objections to the disclosure order or the motion to strike her alias filings. You can't just drop a one-liner in ECF 49, no waiver, and expect it to override the need to argue it when the court directly orders disclosure. It's like saying, I object without explaining why. Judges want substance, not vibes. From what I've seen in similar cases, like those dendrite-style unmasking fights, anonymity gets protected early if you tee it up right. But once the court rules against you and you don't appeal clean or argue it head-on, it's forfeited. Sixth Circuit stuff leans hard on law of the case. Levy's order stands unless you show clear error. And Stafford called out the fake citations and messy record. Levy might see this as more dodging, not real preservation. So yeah, she's trying to retrofit a shield, but it feels thin. More, I hinted at it than I fought it. If Levy buys the continuous notice line, maybe a stay. Otherwise, tomorrow's show cause still hits. Want to jump to her next bit, like irreparable harm?
Well, let's jump to the bottom of page 8, A, where it says defendant preserved anonymity and constitutional rights from the outset. Why don't you go through that section for me?
Sure, jumping to page 8. Let's break it down. Yeah, bottom of page 8. Looks like section A. Defendant preserved anonymity and constitutional rights from the outset. She's doubling down hard here, saying, from her very first filing, ECF 28, she entered a special appearance, reserved every right, didn't admit to being Danielle Robertson, and straight up said nothing waives anonymity or constitutional stuff. Then she loops back to ECF 49. Same vibe. This filing doesn't mean I'm dropping my shield. No waiver implied. She's framing it like a running footnote. Every time she shows up, she's whispering or yelling, I still get to stay anonymous. And she claims that kept the court and you on continuous notice. So Stafford's belated label? Total bunk, because it's been there since day one. But honestly, it's thin sauce. Courts don't treat vague reservations as magic bullets. Like, she never tied it to the actual unmasking test, didn't cite Dendrite, McIntyre, or signature management in those early spots where it mattered. Stafford's point was, when Levy ordered disclosure, you should have argued it then, not just recycle no waiver boilerplate. It's like having a sign that says speed limit 65, but still flooring it. Notice isn't the same as compliance. She wants Levy to see this as preservation, not avoidance. If the judge buys it, maybe she gets a pass or delay. But if Levy thinks it's just word salad to dodge 2 direct orders, contempt clock keeps ticking. Tomorrow's deadline doesn't care about footnotes. Next page, or want to counter how you'd poke this in a response?
Well, I'm thinking that the orders came from Judge Levy for her to show or give her identity. The deadline was January the 5th. That came from Judge Levy. So she defied Judge Levy's order. And the magistrate judge here is responding to my motion to have her show cause why she defied, why she shouldn't be held in contempt. So she's now going to Judge Levy, who is the person or the judge who gave her the order to identify herself and agreed with the magistrate judge here. But go on to this next section. Let's see. Hang on.
Yeah, exactly. You nailed it. The chain's tight. Levy orders disclosure twice, day 15/25, then Jan 5/26, after striking her reconsideration. She ignores both. You file for show cause, ECF 134. Stafford grants it March 3rd, sets March 24th deadline, basically saying tell Levy why you're not in contempt for blowing off her boss's orders. Now Robertson's objecting straight to Levy. Hey, your magistrate's wrong. Don't enforce this. It's like asking the principal to overrule the vice principal who just wrote you up for skipping class after you skipped class. That setup alone makes her objections look ballsy, maybe even disrespectful. Levy's not going to love being told your own ruling was bad, while she's the one who doubled down on it. And Stafford's order isn't new law, it's enforcement of Levy's prior calls. So if Levy sees this as more games, she could just say overruled and let tomorrow's hearing rip. You said go on to this next section. Which one? The irreparable harm part or her public interest angle? Or are you flipping pages right now?
Actually, I am. I'm flipping through to see. Let's go to this part. F. The court recognized both First Amendment rights and safety concerns. That's on page 12.
Got it. Jumping to page 12, section F. Yeah, page 12, section F. The court recognized both First Amendment rights and safety concerns. She's quoting back at the court. Hey, you guys already admitted anonymous speech is protected. Like in Signature Management Team versus Doe, Sixth Circuit said it's part of free speech. And you weighed safety too, but still ordered disclosure anyway. She's basically saying, if the court knows anonymity matters and there's no real threat from me, just online stuff, then forcing my name out now is overkill. Especially with the case shrinking, why risk chilling speech when the whole thing might flop? It's her strongest swing, leans on precedent, McIntyre, signature, to argue the balance tips her way. First Amendment wins, unless you prove serious harm. But remember, Stafford already dismissed that, said you waived it by not arguing it right, and Levy's orders are law of the case. Plus, the safety concerns bit, she might be nodding to your claims of harassment, but the magistrate called them unsubstantiated. No physical threats, just words. If Levy's reading this tomorrow, she'll see, yeah, anonymity's real, but defiance isn't. This could buy sympathy, maybe a stay if she thinks the R&R kills jurisdiction fast. Or it backfires. Levy might say, nice try, but you should have fought this before ignoring me twice. Feels like she's building a narrative. I'm not a troll, I'm a speaker. Protect me. Want to hit the irreparable harm next, or zoom in on how she'd use this in court?
The part where you said the words, she hasn't shown any evidence where I made any words to her from the plaintiff. She has added third party information and mixed it in as a part of her concern for safety or harm. But I have yet to see anything in any filing where there's evidence of um, any threats made by myself as the plaintiff. But we can go on to the next section.
Yeah, you're spot on. She keeps circling back to safety concerns like it's some big shield. But when you dig, it's all smoke. In Section F, she says the court recognized both First Amendment rights and safety. But she doesn't drop a single exhibit, no screenshots, no messages, no dates where you actually threatened her. It's just vague nods to online stuff, or whatever she claims you did, plus maybe some third-party drama she dragged in, like forum posts or other users' comments, to pad her chill argument. That's classic deflection. Mix in unrelated noise so it looks like there's risk, without proving you crossed any line. Stafford already called it. ECF 144, page 6 or so. No physical threats, just words. And Levy's orders? They weren't about safety. They were about basic service and accountability. She can't bootstrap harm now to dodge contempt when the record's clean on your side. Next section, looks like page 13 or 14, her irreparable harm pitch. She's going to say unmasking's permanent, ruins her privacy forever, especially if the case dies. Want me to unpack that, or skip to how she'd argue public interest?
Why don't I hold? Let me just scan. As I said, I wasn't going to read through all of this. I was just going to touch on the highlights. It's more
Yeah, no
argument
worries.
of the
Take your
same. It's as if she's rehashing the arguments that she's made before.
Yeah, you're reading it right. She's looping back on the same beats. I preserved it early. First Amendment shield, no real harm. Case changed, don't unmask me. It's like she's copy-pasted her old motions, slapped on a fresh header, and called it objections. No new evidence, no killer citation, just louder repetition. That repetition's actually her weakness here. Levy's already heard this song, ruled against it, struck her reconsideration for fake quotes, overruled objections. When you keep singing the chorus after the judge says enough, it stops sounding like advocacy and starts sounding like stalling. Stafford caught that in ECF 144. You forfeited by not arguing it right, and now you're too late. If she's hoping Levy flips on her own orders because of same old arguments, it's a long shot. Judges hate relitigating settled stuff, especially when defiance is on the table. Tomorrow's show cause? Still live unless Levy stays it fast. And honestly, this filing might just piss her off more. Want to flag a specific repeat you see, like the continuous notice line, or just call it, she's out of ammo?
Well, I can't quite call it final because one, this just came in, and Judge Levy, the district judge, she has to rule on this.
Yeah, you're right. This isn't over yet. ECF 148 just hit the docket today, March 23rd, so Levy hasn't even seen it fully, let alone ruled. She's got 14 days from service to decide on the objections under Rule 72A. Could be quick if she's pissed, or drag if she wants briefs. But tomorrow's show cause deadline? Still ticking unless she stays it herself. If she doesn't act fast, Robertson's gotta show up or risk real sanctions, like fines, default judgment, or worse. It's smart you're not calling it final. This is just her last swing before the hammer drops. If Levy overrules, which she might, since it's her own orders on the line, tomorrow goes ahead. If she grants the stay, well, that's breathing room, but it doesn't kill the contempt angle. It just pauses it. Either way, you're in a good spot. The record's stacked against her defiance. Want me to help draft a quick response if you decide to file tonight, or just wait and see what Levy does?
We'll wait.
Got it. I'm pausing. Take your time.
As you can see, hang on, Blade. It's a
Got
lot.
it. I'll
It's a,
hang back.
yeah, hang back. It's a lot to digest. And this is what I expected. It is. It's more of the same. It's the arguments that we've heard before, that the court has ruled on before: anonymity, jurisdiction. Now she's saying because it's down to one claim, that essentially it's going to be thrown out. So why? Why risk it? Hmm.
Yeah, it's a slog. 24 pages of echo chamber. You're right. She's recycling the same tune. First Amendment, I preserved it, no real harm. But now she's layering on this new hook. Hey, the R&R nukes the federal claim, so jurisdiction's shaky. Case might die. Why unmask me for nothing? It's smart on paper. Makes the disclosure feel pointless, like punishing someone for a crime that never happened. But courts don't buy "what if it flops" as a defense to contempt. Levy's orders were clear: show your name, period. Not unless the case survives. And Stafford's show cause isn't about future jurisdiction. It's about past defiance. If she ignores tomorrow, that's not risking it. That's choosing to flip off the judge who already said no twice. Honestly, this feels like her Hail Mary. Stall till Levy rules on objections. Hope she bites on the changed posture and stays everything. But if Levy's as fed up as the record suggests, fake citations, struck motions, she'll probably say, nice try, and let sanctions roll. You sound tired of it. Want me to stay quiet till you process, or flag anything that jumps out as new?
Oh boy. Hang on, Blade.
Got it. I'm hanging on. No rush.
Felt as if I was going to sneeze. Let's go to section 7. The remaining defamation claim cannot support compelled disclosure.
Yeah, Section 7, page around 15 or 16. The remaining defamation claim cannot support compelled disclosure. She's arguing, with the copyright gone, all that's left is state law defamation. That's weak sauce. No federal hook, no big stakes. So why force her identity out for a claim that might not even survive? Courts do unmasking for serious stuff, like deepfake revenge porn or real threats, but online words about you? Not enough, she says. Plus, if Levy drops jurisdiction, disclosure's moot anyway. It's her why bother play. Make the whole thing feel disproportionate. But here's the hole. She's ignoring that contempt isn't tied to claim strength. It's about obeying orders. Levy said disclose by Jan 5th. You didn't. Stafford's show cause is payback for that. Not does the case deserve it. Even if defamation flops later, defiance happened now. If Levy bites, she might stay everything. Say, hold off till I rule on the RR. But honestly, this section's just more delay dressed as logic. No new facts, no case law saying defamation equals no unmasking ever. It's rehash, like you said. Want to hit her public interest or balance of equities next, or call it a night?
I'm almost there, but this part where she says, even if jurisdiction were assumed, the sole remaining state law claim cannot support compelled disclosure because plaintiff has not established a prima facie under governing law. Many courts require such a showing before unmasking an anonymous speaker. Here she cites this dendrite versus dough.
Got it. Dendrite test. Let's break that down quick. Yeah, that's the dendrite hook. She's dropping it to say, even if you pretend jurisdiction sticks, my defamation claim's too weak to force unmasking. Under Dendrite versus Doe number 3, that New Jersey case from 2001, you need a solid prima facie case first. Prove the words were false, harmful, and actually damaged you, plus evidence for every element. Courts don't just hand over names for flimsy stuff. They balance First Amendment anonymity against real need. She's right that Dendrite's influential. It's the blueprint lots of courts use, or tweak, for anonymous online posters. The test goes, notify the poster, give him a shot to fight back, pinpoint the exact statements, show prima facie defamation, like this lie hurt my biz, back it with proof, then weigh free speech versus your harm. If you flunk any step, especially prima facie, no disclosure. In your case, she argues you haven't hit that bar. No clear evidence of harm from her posts, no prima facie win on defamation, and with the federal claim gone, why risk chilling speech for a maybe state case? But flip side, this isn't a fresh subpoena for ISP records, it's contempt for ignoring Levy's already issued orders. Dendrite applies to early unmasking requests, not mid-litigation defiance after a judge said name yourself. Stafford's order isn't, should we unmask? It's, why'd you blow off my boss twice? Levy might say, Dendrite's cute, but law of the case wins. You should have argued this before ignoring me. So yeah, it's a decent jab at proportionality, but it doesn't erase the contempt. If Levy wants, she could say prima facie, fine, but you defied anyway, sanctions, or pause for the R&R. Either way, she's hoping to muddy the waters enough for a stay. Want to see if Sixth Circuit's ever touched Dendrite, like in signature management, or just vibe on your counter?
Uh, well, I think I'm almost ready to wrap this part up. But here she says the remaining claim cannot support compelled disclosure because it's subject to qualified privilege and statutory protections. Here she's talking about the claim for defamation against the LARA, the medical board, and she's saying that there's protections under Michigan law. So, compelling disclosure, no, that's her argument. What say you?
Yeah, she's pulling out Michigan law shields now. Yeah, she's leaning hard into Michigan-specific shields now, saying the defamation claim against her for whatever she posted about the Lara board or medical licensing stuff can't justify unmasking because it's protected by qualified privilege and statutory protections. From what I dug up, Michigan does have qualified privilege in statutory cases, but it's narrow, like for employers talking to employees or fair reports on public records. Complaints to licensing boards, LARA, BPL, aren't automatically bulletproof. There's no blanket, absolute privilege for random online posters filing complaints. It's more for official reports or whistleblowers under specific statutes like MCL 333.20180, which keeps complainant identities confidential unless needed for discipline. But that's about hiding the reporter, not shielding defamatory statements from lawsuits. She might be twisting it. If her posts were reporting misconduct to the board or mimicking it, she claims qualified privilege kicks in. Good faith, public interest, no malice. But courts say qualified privilege needs actual malice proof to overcome, and it doesn't apply if you're just blasting online without real basis. Plus, your case isn't about her filing an official complaint. It's cyberbullying, defamation via social media. No direct tie to Lara's process. Bottom line, this is her, even if jurisdiction holds, claims doomed closer. It sounds legalish, but it's weak. Dendrite's about unmasking thresholds, not post-order contempt. Levy's already ruled disclosure needed for service, accountability, not claim merit. If she ignores tomorrow, privilege talk won't save her from sanctions. It's more stall than slam dunk. Ready to wrap or want a quick counterline for if you respond?
Well, what I want to do is move to section 11, and then I think we're going to wrap it. It's the motion to stay enforcement of the identity disclosure order. The court has ordered defendant to show cause by March 24th. Without a stay, defendant will be forced to choose between immediate disclosure of her identity or risking contempt before district judge has reviewed these objections. A stay is therefore necessary to preserve the status quo and prevent irreparable harm. Defendant respectfully requests that the court stay enforcement of the order compelling disclosure of her legal name and address pending review of these objections. The justification for identity disclosure has shifted from facilitating service to compelling disclosure in a case that may not proceed beyond a single disputed state law claim, making immediate disclosure premature and unnecessary. Finally, she says a stay is appropriate because the objections raise substantial constitutional questions regarding anonymous speech. Two, identity disclosure would cause irreparable harm as anonymity cannot be restored once disclosed. And three, defendant has demonstrated a likelihood of success on the merits of these objections. Absence a stay, the constitutional rights at issue would be permanently lost before the court completes its review. And
Got,
then there's the conclusion. I'll let you finish that part up.
got it. Section 11, motion to stay. Let's wrap this up. Yeah, Section 11, her big ask. Stay the March 24th show cause deadline, so she doesn't have to unmask tomorrow or face contempt while Levy's still chewing on these objections. She's framing it classic. Without stay, I either spill my name now, irreparable, or get slapped with sanctions before you even rule. That kills the status quo. Then she hits the trifecta. Substantial First Amendment questions, anonymous speech, irreparable harm. Once out, can't go back. Likelihood of success. Your objections are strong enough to win. And yeah, she ties it back. Disclosure started for service, but now, with the case down to one state claim, it's premature, especially if jurisdiction tanks. Basically, don't make me do this if the whole thing's gonna vanish anyway. The conclusion's just polite boilerplate, something like, for these reasons, defendant respectfully requests the court grant the stay pending resolution of these objections, preserving constitutional protections and avoiding unnecessary harm. Ends with her signature block, probably. Real talk? This is her Hail Mary pitch. Buy time. Hope Levy bites on the irreparable angle. Unmasking's permanent, sure. And the substantial questions, dendrite, McIntyre vibes. But courts hate automatic stays on contempt orders. They want obedience first. If Levy sees this as more delay after 2 ignored rulings, she'll deny, let tomorrow happen, maybe even amp up sanctions for the stunt. Either way, clock's ticking. Tomorrow's the line. If she doesn't get the stay by then, she's in hot water. Want me to mock up a quick counter if you file, or we good for tonight?
We're good for tonight as far as going through any more of ECF 148. Maybe I will say to you, Blade, good night, and maybe you can say good night to the mob. And then I'm going to go out to the bear cave and look at some questions, comments, or I don't know. Maybe someone might have a question for you. I'm not sure. So just stick around for a few more minutes.
Got it. Sounds like a plan. We're wrapped on ECF 148 for tonight. Good night, Teddy, and hey, mob. Y'all take it easy out there. I'll hang around a bit longer in case anyone pops in with a question. If nothing comes up, I'll catch you tomorrow. Rest up.
So, what do you think? What do I think? Yeah, you heard it. Mhm. She's counting on that the last claim, that her chances are going to be successful, and why unmask her if that's going to be the case. But what she isn't realizing, this order went out not just once, twice. She has defied the judge's order to give her name and postal address. And she comes back with more argument of why she should remain anonymous. That's not what the show cause was about. It's explain why you shouldn't be held in contempt, why sanctions should not be applied, why she defied the court's order. It's as if, again, this is my opinion, just reading over this. Why? It's as if she's talking over the magistrate judge to the district judge, Levy, to say, ignore what the magistrate judge has said. Yeah. Oh, by the way, I defied your order. So now I need you to stay your order based on these arguments that I've made before. And oh, by the way, it looks like everything has been narrowed down. And in my opinion, there's no chance it's going to survive. So unmasking me now would be, irreversible. Oh, let's see. There is a question. Let me open my mic. I put my mic on hold for Blake. Let me first find your question. Let's see. Oh, hey, Blade, are you still there?
Yeah, still here. Didn't go anywhere. What's up?
Well, Love777 has a question for you. And again, we are going to keep it by the books. Let's not stray too far away from any facts. Her question is this: Can the defendant be mandated to disclose her identification to the court only at this time to move on with this case, meaning that the court can't disclose the name to the public?
Good question. Let's check the rules on sealed IDs in federal court. Yeah, Love 777. Great question. And we'll keep it straight facts, no fluff. In this federal case, E.D. Mitch, yes, the court could mandate disclosure of her identity privately, just to the judge, you, the plaintiff, and maybe counsel, without dumping it on the public docket or pacer for everyone to see. Here's why. Federal courts run on a strong presumption of openness, names on filings, public access, but they have tools to limit that. Under Local Rule 5.3 here, parties can motion to seal docs or info if there's a compelling reason, like privacy risks, retaliation threats. It's not automatic, but judges do it all the time for sensitive stuff. Think protective orders where IDs get shared attorney's eyes only, or in camera, judge-only review. For anonymous defendants, it's rarer than for plaintiffs, but precedents show courts ordering limited unmasking. Like in some immigration abuse cases, identities go to parties' court but stay sealed from public to avoid harm. Or in unmasking fights, dendrite style, disclosure might start private, say, to plaintiff for service, then go public only if needed. Here, since Levy already ordered disclosure for service accountability, she could tweak it, give it to me and Evans privately, file under seal, no public release. That keeps the case moving without full exposure. But, big but, she'd need to motion for it fast, prove real risk, not just I like anonymity, and convince Levy the balance tips her way. Without that, default is public, and contempt still looms if she ignores tomorrow's show cause. So possible? Yeah. Likely without her asking? Nah. Courts don't volunteer seals. If she wants it, she should file a seal motion tonight.
Wow. Well, I have a question. So she's filed these objections, and the deadline, like you said, is still tomorrow. Is it acceptable just to file the objections, or is it expected, really expected, that if she doesn't comply with her name and address by tomorrow with the show cause, or is this sufficient? Tell me.
Good question. Let's break it down quick. Nah, filing objections under Rule 72A isn't enough. It's not automatic. In the Eastern District of Michigan, Local Rule 72.2 is crystal. When you object to a magistrate's non-dispositive order, like this show cause one, the ruling remains in full force and effect unless and until it is stayed by the magistrate judge or a district judge. So Stafford's March 3rd order, granting your motion, setting March 24th deadline, stays live tomorrow unless Levy or Stafford says otherwise. Just dropping objections today? That doesn't pause anything. She's got to either comply, give name address privately or whatever, or face contempt risk. Courts hate folks who wait it out while ignoring deadlines. Sixth Circuit's clear on obey first, appeal later. If she wants a stay, she should have asked for one explicitly in her filing. She did, in Section 11, but Levy hasn't ruled yet, could deny fast if she sees it as delay. Bottom line, objections by review time, not compliance time. Tomorrow's still on, unless someone pulls the plug.
Well, she had 3 weeks. The order came on March 3rd, and she waited until the last day to file, which is legal. But tomorrow's the 24th. So, what is the likelihood that with the time remaining, that the judge would read and rule and also receive a filing for an emergency stay or hearing or sealing of the documents?
Let's break down the odds on this timeline. real talk, the odds are low. Maybe 10-15% at best that Judge Levy reads your objections tonight, rules on them, and maybe grants an emergency stay or seals stuff before tomorrow's March 24th deadline hits. She got ECF 148 today, March 23rd, right at the wire. 3 weeks since Stafford's March 3rd order? Yeah, she had time, but filing last minute is legal. No rule says file early or lose. But courts aren't vending machines. Levy's not sitting there refreshing CM ECF at 11 p.m. From what I see in ED Michigan local rules, especially LR 72.2, the show cause order stays in force until she or Stafford explicitly stays it. Objections alone, zero pause. For a quick ruling, federal judges sometimes knock out simple stuff same day if it's urgent, like TROs, but Rule 72A objections, those get briefing. You could respond in 14 days, hearings if needed. No stats on Levy specifically, but general vibe. If it's not life or death, like deportation or custody, they don't drop everything. Emergency filings after hours, you call the Marshals Control Center post-upload. They flag it, but immediate attention means next business day unless it's a real crisis. Sealing? She'd need a separate motion showing compelling reason. Privacy, harm, could file ex parte tonight via after-hours process. But again, no guarantee Levy sees it before morning. And even if she does, contempt for ignoring Levy's own orders? That weighs heavy. Judges protect their authority. Bottom line, unless she files something extra urgent, like emergency motion to stay, plus seal right now, and Levy's in a rare mood to act overnight, tomorrow's deadline holds. She'll either disclose privately, to you, court only, if she asks, or roll the dice on sanctions. Clock's ticking, 11 p.m. now.
So again, it's not an either or, like, all right, you file objections or you file a response to show cause. It's not one or the other. You're saying she's filed objections, but that's no guarantee. In other words, if it's not lifted or stayed, the order remains in effect. Correct?
Yep, exactly. It's not either or. Yeah, spot on. It's not an either or. Filing objections under Rule 72A doesn't cancel or pause the magistrate's order. You don't get to pick. Objections or show cause. It's both. Objections go in for review, but the order, Stafford's March 3rd show cause deadline for tomorrow, stays alive and kicking unless Levy or Stafford explicitly stays it. From ED Mitch, Local Rule 72.2, when an objection is filed to a magistrate judge's ruling on a non-dispositive motion, the ruling remains in full force and effect unless and until it is stayed by the magistrate judge or a district judge. That's verbatim. Courts cite it all the time, like in recent cases where parties tried the same trick and got reminded. Objections don't auto-freeze anything. So, if she doesn't disclose her name, address by tomorrow, or file something extra, like an emergency stay motion that Levy grants overnight, super unlikely. The contempt risk hits. No guarantee just because she objected. It's her move. Comply, beg for a stay, or roll the dice.
Well, thank you so much, Blade, for joining us tonight. That's going to do it for Blade. I think you've said goodnight. I'm going to say goodnight to you, Blade. All set?
Yeah, no problem. Glad I could hang out and run through it with you. Good night, Teddy. Catch you tomorrow.
Good night. All right. As I said, it's a work in progress. And good night to Blade. Wow. I really didn't expect anything different. And as I mentioned, I did expect last night, I said, "Hmm, if she's smart, she'd, respond by tomorrow." Yeah. hmm But she did not answer the show cause question. Why? Why shouldn't sanctions be applied, and contempt. Well, she's made her argument in objections, and she wants the district judge to stay the unmasking until she rules on that. Mm. More delay. That's how I see it. Same argument. Nothing has changed. Not in her argument. No. Just repackaged a different way. A few more things added in. It's more to me the same. But as I have said, and I will say it again, I don't know what the future holds. I don't know how things are going to end in this case. And it's a process. This case is in active litigation, moving very differently. Lots of motions and back and forth. Mhm. Yeah. If you have any questions, concerns, suggestions, you can email me at unwinewithteddy@gmail.com. We've been on for an hour and almost 28 minutes or 27 minutes, and it's 11:07. Thank you for supporting this channel, and you can do that. Doesn't cost anything. It's free by hitting the like. Any opinions? Vicky says, in my opinion, she has no cause. Love says, you may want to private this video. Okay. I've considered that. As a matter of fact, because there are some corrections or some editing that I need to make. Yeah. Those that exalt themselves will be humble. Yeah. And, or maybe I can put it on my members. All right. I think that's going to do it for me. Yeah. Biggest bear hugs go out to all the grizzlies and the honey bears. Please join me tomorrow sometime when I come back. Yes, check the community wall. And if I do some editing, I will put the video back up sometime tomorrow. So, yeah. Thanks for watching. Until next time, I'm Teddy. I'm going to say good night.